All right, I'm going to call the public hearing of the Sentencing Guidelines Commission to order. I could ask everyone to stop talking and, all right, come to order. Thank you. So hi, everyone. This is the public hearing for the Sentencing Guidelines Commission. I have some information to read through to set us up for this hearing. And then we have a few people who are signed up to testify, so we'll move on to testimony. And along the way, I'll give information for anyone who has not yet signed up who would be interested in doing so. So I'm going to read my script now. So good afternoon and welcome. My name is Kelly Lynn Mitchell, and I'm chair of the Minnesota Sentencing Guidelines Commission. It is now 2:07, and the November 20th, 2025 public hearing is called to order. This hearing is taking place at the Minnesota Senate Building, room 1100, 95 University Avenue, West St. Paul, or University Avenue West, St. Paul, Minnesota 55155. I'm here along with commissioners. So in the room are Commissioners Fraze, Commissioner Middlebrook, Commissioner Mazzaros, and myself. Online, we also have Commissioner Morin, Commissioner Ladd, Commissioner Saxena. I think that's everyone. And Commissioner Keefe. I think I have everybody there. The public hearing today is being held to consider proposed modifications to the 2025 Minnesota Sentencing Guidelines and commentary resulting from the Commission's comprehensive review. By unanimous vote, the Commission preliminarily adopted the following proposed modifications at its meeting on October 9th, 2025. I'm going to describe those modifications very briefly. So the first set of modifications were changes to the Minnesota Criminal History Score calculation. As a result of its comprehensive review, the Sentencing Guidelines Commission, as its result of the comprehensive review of the Sentencing Guidelines, the Commission proposes changes to each of the 4 components of the criminal history score: prior felonies, custody status at the time of the offense, prior misdemeanors and gross misdemeanors, and prior juvenile adjudications. Second category, changes to offense severity. As a result of its comprehensive review of the sentencing guidelines, the Commission proposes to increase the severity level assigned to several offenses, to replace one sentencing modifier with an increased severity level ranking, and to decrease the severity level assigned to one offense. Each proposal amends Guidelines Section 5A, the offense severity reference table, and Section 5B, severity levels by statutory citation, and other amendments are as stated. The third area are other changes. In addition to the changes to criminal history score calculation and offense severity, the Commission, as a result of its comprehensive review of the sentencing guidelines, also proposes to make changes to number one, clarifying the guidelines' purpose and principles. Number 2, clarifying the burden of proving out-of-state offenses. 3, displaying ranges in shaded cells and revising example offenses on the grid. And 4, adding a true first offender departure factor to the non-exclusive list of mitigating factors that judges can use when articulating substantial and compelling reasons for departing from the sentencing guidelines' presumptive sentences. You can access a complete copy of the proposed modifications on our website. It's a really long website section thing here, so I don't think it's worth it for me to spell it out. But basically, if you go to min.gov/sentencing-guidelines, go into the upcoming meetings section, and you can get a complete copy of those proposals. There's also a link on the very front page of our website. The banner that rotates also has a link that will take you directly there. These have been available on the website since October 20th, 2025, the same day the notice of this hearing was published in the State Register. There are a limited number of public inspection copies available in this room, together with website access information. Okay, so now I'm going to go over the public hearing procedures. So if you wish, you may make spoken or written statements today regarding the proposed modifications. You can also address questions about the proposed modifications to the Commission, its staff, or witnesses. And if you have made a spoken statement, the Commission or its staff may ask questions of you. Members of the public who registered to testify before today will be called first in the order that they registered. If you would like to testify about the proposed modifications today and you have not yet registered, you must first register your name, address, telephone number, and the names of any individuals or associations that you represent in connection with the hearing. If you are here in person, please sign in with staff right now. If you're attending remotely, please email your registration information to staff at sentencing.guidelines@state.mn.us right away. You will then receive the meeting access information. If you have trouble, you can also call our staff at 651-296-0144. After everyone has testified, the public hearing will end. The Commission will hold the record open for 5 calendar days after the public hearing to accept written comment. Written materials must be received no later than November 25th, 2025. Any person who wishes to provide a written statement may do so in one of 3 ways. By delivering the written statement to the public hearing today, by sending the written statement by U.S. mail to our address, to the Minnesota Sentencing Guidelines Commission, and our address is 658 Cedar Street, Suite G58, St. Paul, Minnesota, 55155. Or by emailing the written statement to our email address, which is sentencing.guidelines@state.mn.us. The Commission will give due consideration to all written comments received within the 5-day comment period, as well as all written comments received up until now. The Commission will meet Thursday, December 18th at 1 p.m. to finally adopt or reject its proposal. That meeting will take place at the Minnesota Department of Corrections in the Itasca Training Room, which is in the ETC Building West Entrance at 1450 Energy Park Drive, St. Paul, 55108. With remote participation is optional. All right, so 2 people have testified in advance to testify today. I will call the first one in just a moment. All right, so the 2 people that have testified are Morgan Kuntz and Anna Hall. So why don't we go ahead and bring forward Morgan Kuntz.
Thank you. Good afternoon, Chair and Commissioners. Can you hear me?
Yes, we can hear you. Welcome to the Commission.
Thank you so much. I'd like to thank the Commission and the Steering Committee for their work on this comprehensive review. I am speaking today in support of the recommendations outlined in the documents. I would also like to say that I'm the Criminal Director of the Hennepin County Attorney's Office and have consulted extensively with the staff at the Hennepin County Attorney's Office in my comments today. I'm going to highlight several proposed changes that I believe are particularly well considered. The first of which is reducing the decay factor for criminal history points. This will help focus the sentencing on the current offense and away from past conduct for which the person has already been sentenced. The current decay period of 15 years is not needed to protect public safety because prosecutors can seek aggravated sentences and upward departures in appropriate cases. Reducing the decay period to 10 years moves Minnesota more in line with practices in other states and research on recidivism. This is a smart move that the Hennepin County Attorney's Office supports. Second, the elimination of the juvenile points from the criminal history score is another smart move. The current system of increasing a criminal history score for straight juvenile offenses is not consistent with the purposes of juvenile law as outlined in Minnesota Statute 260B001. That statute calls for protecting public safety and also recognizing the unique characteristics of children. Juvenile law is about rehabilitation and returning youth to law-abiding behavior. At the same time, the most serious juvenile offenses, those that result in EJJ or adult sentences, will still add criminal history points. The Hennepin County Attorney's Office supports the elimination of juvenile of points from straight juvenile matters. 3, Converting the custody status point to a durational increase is an appropriate change. Current practices allow this point to be waived, which makes it a point of negotiation similar to the range of sentences already within the grid. As such, the custody status point essentially broadens the range of possible sentences to cover 2 full boxes. Making the custody status point an enhancement of the presumptive sentence is a more equitable and consistent way to handle offenses committed by people in custody or on probation. Finally, the Hennepin County Attorney's Office supports the changes to allow prosecutors and courts to consider offender-related factors for durational departures and to allow mitigated departures based on a lack of any prior conviction or stay of adjudication. These 2 changes will give greater flexibility to prosecutors to seek sentences that are appropriate to the offender and the offense. There are cases where the presumptive prison sentence is too high, but a jail sentence of less than 1 year is too low. This change will provide flexibility to prosecutors and to judges to achieve a just result based on the specifics of the offense and the offender. Thank you very much.
Thank you for your testimony today. Are there any commission members who have questions? All right, hearing none. Thank you so much for coming to the hearing.
Thank you.
I will go ahead and the next testifier is Anna Hall. Thank you so much for coming into the hearing today, Ms. Hall. Please proceed when you're ready.
Thank you. Good afternoon. My name is Anna Hall. I'm a community defense attorney at the Legal Rights Center in Minneapolis, where our mission is to provide high-quality legal representation in criminal court to those communities who have historically been denied access to that representation. The Legal Rights Center strongly supports all of the proposed changes to the sentencing guidelines, except the increases in offense severity rankings. By reducing the decay periods and eliminating prior juvenile adjudications, the Commission acknowledges 2 core truths: that no person can be defined by one act, and that all people should be permitted the chance to grow and change. People with convictions have already been held accountable through the sentences imposed on their previous cases, and likely through the vast collateral consequences they have faced in the wake of those convictions, including loss of housing, employment, benefits, various other collateral consequences. Moreover, research shows that as people age, they become significantly less likely to commit crimes. And for both of those reasons, the Legal Rights Center is in support of the changes to the decay period and juvenile adjudications in criminal history scores. The LRC is, however, strongly opposed to increases in offense severity rankings. As a community member and an attorney who practices in this area, I have no sense of why these decisions are being made beyond political considerations. A question from our organization is what evidence supports increasing offense severity rankings for these offenses. We are particularly concerned about the severity level increase in assault 4 charges. I'd like to provide some context from our practice for this type of charge for those on the commission or in the public who may not be familiar with the kinds of situations that lead to assault 4 charges. We see assault 4 cases charged frequently in situations where officers either neglected to or outright refused to de-escalate. Often, officers behave in a way that any normal person would consider highly escalatory or even dangerous. This happens frequently with community members who are experiencing serious mental health issues. It is law enforcement's responsibility to ensure the safety of community members, not the other way around. And yet in these instances, law enforcement often fails to do so, and yet it is community members who are ultimately charged for a criminal offense. I would offer an example of the kind of demonstrable bodily harm, which is the standard in the statute, that can cause someone to be charged with 4th-degree assault. In one case I litigated recently, an officer discovered a chipped tooth several hours after interacting with my client. That was enough for a prosecutor to bring 4th-degree felony charges. I would note also that the proposal allowing judges to consider the same factors for both durational and dispositional departures is not being considered today. I would urge the commission to take up that proposal again. There is simply no good reason why that distinction should remain. It's my understanding that there's, from, attending previous meetings, that there's some concern around Supreme Court and Court of Appeals precedent, but the commission has the power to change this and to reinitiate consideration at the courts and reinterpretation by those courts of the commission's rules and regulations. So with that, I will close my comments. Thank you for hearing from me today and for these thoughtful proposals.
Thank you so much. Stick there for just 30 seconds if you wouldn't, because we have the ability to ask you questions.
Yes.
So are there any questions or comments from members of the commission? All right, seeing none. Thank you so much for your comments today. I appreciate you coming down.
Thank you.
All right, it looks like we have another person who has signed up to testify, Marvina Hayes. Please step forward. Welcome to the commission. Please just state your name on the record and then thank you. Proceed whenever you're ready.
Hello, everyone. My name is Marvina Haynes. Good afternoon. My name is Marvina Haynes, and I am the founder of Minnesota Wrongfully Convicted Judicial Reform. I am here today not just as an advocate, but as a sister, a mother, a community member, and someone who has lived the lifelong impact of wrongful incarceration. For more than 18 years, my family fought for my brother Marvin Haynes, who was wrongfully convicted as a child and lost his entire youth behind bars. We did not just fight for him, we fought for every family who has been ignored, silent, or left behind by Minnesota criminal law legal system. Minnesota Wrongfully Convicted Judicial Reform stands with dozens of families, those whose loved ones are incarcerated, many still fighting to prove their innocence. We stand with mothers who cry onto their pillow at night, grandmothers who are raising grandchildren left behind, youth who grew up visiting their parents through glass, and an entire community shaped by trauma and safety. And that's why I'm here today, and that's why this matters. The sentencing guidelines for us are not just about numbers on a grid. They are the difference between a child coming home or losing their future, a parent receiving treatment instead of decades in prison, a sentence that fits truth, or one that destroys a family. For years, Minnesota communities, especially for Black, Brown, Native, and low-income families, have been over-policed, overcharged, and over-sentenced. And many of the people we support at Minnesota Wrongfully Convicted Judicial Reform are sitting in prison today because sentencing tools were misapplied, inflated, and unfairly used against them. At Minnesota Wrongfully Convicted Judicial Reform, we support this change, especially around eliminating juvenile points. We believe that no child should carry a lifelong burden for mistakes made at the age 12, 13, or 14. This change protects our youth for being sentenced twice, once in juvenile court and another one in adult court. We also support reducing the misdemeanor decay period. People should not be punished forever over an old, low-level mistake. We believe 7 years is more humane and more fair. Out-of-state scoring practices, too many families have been harmed by criminal history scores. We believe prosecutors requiring to actually prove priors builds fairness and truth. Sentences should not reflect safety and justice. Sentences should reflect safety and justice, not just punishment for punishment's sake. Even with these implements, we still see problems. Some offenses severely levels increase. We still have racial disparities remaining. Too many people are still wrongfully incarcerated in Minnesota prison. Minnesota continues to lead the nation in racial gaps in imprisonment. That's why we are calling on independent transparency review processes, opportunities for resentencing, continuing partnership with community organizations close to the work, like Minnesota Wrongfully Convicted Judicial Reform. This decision made in this room today will impact generations. This will shape freedoms, family stability, and also community healing. We ask the commission to adapt these reforms and to continue to work with communities and organizations like Minnesota Wrongfully Incarcerated Convicted Judicial Reform to ensure Minnesota leads the nation, not only in sentence reform, but in preventing wrongful convictions altogether. This is not about policies for us. This is personal. Our families deserve justice. Our youth deserves futures. Minnesota deserves a system that protects the innocent, hold the guilty accountable fairly, with honors and dignity for every person and every Minnesotan. Thank you so much. My name is Marvina Haynes, and I'm always nervous when I apologize about that.
You did a wonderful job. Thank you so much for coming in today. It was really a really powerful statement, and I'm glad that we got to hear that.
Thank you.
Is there anyone on the commission who has questions? Great. Thank you so much.
Thank you.
That all the people, so that's everyone who signed up? Okay. All right. Okay, so that concludes the testimony of those who've registered to testify in advance. We'll now call on those who registered. Oh, sorry. Already done that part. I'm just trying, I have a script and I'm trying to figure out which part of it I need to read. Okay. So what we're moving on to now. Is there anyone else in the room who is interested in testifying today? First call. Please come forward, state your name, and proceed when you're ready. And I'm going to pause you for, actually, let me pause you for a second because they're going to register you. And while you do that, I'm going to give instructions for anyone else who might be listening who is also interested in testifying. So, okay, if you would like to testify, I just want to reiterate, please, let me find the things. Gotta find it. Okay, so if you're interested in testifying, you can get in contact with our staff by emailing sentencing.guidelines@state.mn.us, do that right away, or call 651-296-0144. So that is for people who might be listening online and may be interested in testifying. Anyone else in the room who's interested in testifying, staff are coming around and you can fill in the request to testify there. Please go ahead. State your name.
Yeah. Thank you all. I like. What's up, everybody? Hi. I want to just take this opportunity to invite us to think about the kind of oh no, I've already given. It's Raj. The kind of research that is now in the mainstream about restorative transformative justice practices, and yet it continuously is neglected when it comes to us considering that in sentencing guidelines. It seemed like it's a community project versus a systems project, and more often systems continue to fail, as Marvina Haynes just pointed out. Fail, especially Black and brown bodies, right? And we hear these stories on a regular basis, and yet your data points are based on the criminality, the crime, the number of times this person has committed an offense, everything but the touch points, the stories, and the things that the root causes of this behavior is not ever considered by the commissioners nor the judges for the most part. So I am imploring this body of commissioners to think about how can you integrate, right, what we know in terms of research that promotes restorative practices and transformative justice work and liberation work in our communities that is allowing us to work through the harm that was caused in the community and address the ripple effects of the harm versus just simply focus on the incident, right? So more often our judicial system is set up to deal with the incident versus the ripple effect. And what we are saying is that we are willing to carry the torch to do the ripple effect, the long-term impact, right, of this work. And let us come into this place to collaborate with systems and humanize the system in many ways, right? It seemed like the research that continues to support how effective transformative justice and restorative justice have been working in our communities is neglected or is often referred to as, oh, that's really good. I'm glad y'all are doing it, but here's what the real work is. It seemed like trained lawyers and judges and right courtrooms seem to be separated from our community, and yet the work that you do in that space continues to harm us generational. A generational impact, as Marvino pointed out, right? So what I'm asking for you to think about ways that right, Ramsey County is doing that work, right? In some ways, John Choi is leading the process and saying, like, we are going to take these cases and we are going to invite the community to look and examine these cases and say, if this case should go to a judge, or should it go to diversion, or should it go to a community that is going to come back together and repair the harm. And more often, right, slowly but surely, we are getting more and more cases diverted to the community of group of people who practice restorative practices from generation to generation, from RJCA and many other organizations come together with people who have been impacted by violence, not directly, but indirectly have been impacted by any of these actions that brought this individual to us in that circle. And we get a chance to examine the stories behind their action. We get to look at the root causes, and it seemed like that is not important. And yet, we also have the University of Research talking, the University of Minnesota, research talks about genetics and the epigenetics and the impact that epigenetics has on the generations to come. It is right here. This is a well-funded organization by the state. And yet you don't recognize some of that research that is coming out of that university, and you continue to carry on the system as if the system is untouchable, right? So I want to implore you all, I want to beg you to think about how you can be creative in putting language and implore the district courts to move towards, right, repairing harm, addressing the harm, restoring people's humanity and dignity, versus how many years should this person spend, right? What does 10 years equals to somebody who has been hurt, harmed, shot? Do you really believe that if a person spends 10 years in prison, that equals to paying off that somebody who has been shot? Do y'all really believe that? I wonder how do you imagine that? What does 10 years equals to? Right? I'm not sure how you come come to this space and say 10 years, 7 years, 5 years, 6 years, 3 years, right? I'm having a hard time because I work in the streets and I know what these communities are feeling, right? They're frustrated, they're angry, right? And yet they are looking to see how can we restore, repair, and then help them also heal, right? Once a case has been decided by a judge, the person who has been harmed, AKA victims, are just on their own. There might be a victim service office, but most victim service officers are not doing the work that needs to be done for the long run. Maybe a year, you might assist them, but for the long term period of suffering, right, that has never been addressed by the courts. And what we are asking you to think about is think about the person who has been harmed. This process does not help the person who is harmed or the person who caused the harm. What it does is to help to instill the fact that we enforce and make people comply. So please, y'all, I mean, think about how can we input that language, right, and move us towards, right, less punitive system and more accountability. Move us towards accountability. Let us hold each other accountable, right, and not think that your punitive system is going to help address the pain in our community. It is not. Right? Richard Rohr often said, right? Pain not transformed will transfer. And we are transferring pain through this system. And I really, really think, right, you all are at the right point, right place, at the right time. You are the leaders that we have been waiting for to help us move in a humane direction, right? As opposed to continue these 200, 300 years of practice of punitive processes that continues to affect and harm Black and brown bodies much more than white bodies. Right? Let us walk through the pain, as Rasmus Menakan say. Let us not walk around the pain. Judicial systems are set to walk around the pain and admire the pain and figure out how to create numbers that will, right, in our mind, right, in our perspective, will address the harm. It is not. It is continuously affecting this process. Let us walk through the pain. Right? I love y'all. Thank you for the time. Appreciate.
Thank you very much.
you.
Is there any member of the commission who has a question or comment?
Ask away, y'all. Please ask questions.
It's a quiet group today. What can I say? Thank you so
This
much
is
for coming to the
Oh.
commission. Oh,
actually, sorry. This is Amadani Keith. I do just want to
yes, go
comment.
ahead.
Really appreciate your testimony today, and I know that you've come to our commission meetings before. And while it's not your responsibility alone, I want to say that I appreciate that you keep lifting this up and also are holding us accountable to having these conversations.
Yes.
And it's conversations that several of us participated in on a national level at a conference that some of us went to this year, and is something that we're questioning. And as a newer member, not totally new now, but newer member of the commission, you know, figuring out how to have this conversation and incorporate some of the thoughts that you have shared today into our work, because it is deconstructing the way that the commission, I think, has understood our purpose in the past, and reconstructing what it really can be in the future. And that is both complicated and necessary. But having your voice at the table in this way is really valuable. So thank you so much for sharing today, and to the others that testified as well.
Appreciate, Commissioner.
All right, any other comments? Yeah, Commissioner Mazzaros.
I just want to say thank you, Dr. Raj. I always appreciate your perspectives. And so, again, I'm a newer member as well and just kind of still figuring things out here,
Yeah.
but there's some stuff that I work on at home on the side, and at some point we'll connect and I'll be presenting some stuff here maybe next year, early next year or something, but along them same lines. So we need to do more to heal and less to hurt. So
Yeah.
agree.
Thank you.
Thank you.
All right. Thank you so much
Thank
for
you.
coming today.
Peace.
Okay, so I think that concludes the testimony of everyone who is registered to testify. I'm going to make one last call, give anyone else who might be listening one last shot. So if you're interested in testifying and you have not done so, step forward. If you're in person or if you're participating remotely, please call 651-296-0144 or email within the next 2 minutes at sentencing.guidelines@state.mn.us. We will pause for 2 minutes. It's 2:43. We'll pause till 2:45. And if anyone else is interested in testifying, we'll ask them to come forward. If not, we'll move on to conclude the hearing today. So we'll just take a 2-minute break.
Because there's so much treatment involved. And then what do they do? What are they to say? They're not gonna something like that. So there's now it's just a full community. Like getting so I really it's like definitely have this opportunity. And that kind of sucks. It's like it is so bad control. Yeah. Just so many. So it's like a thing. Mm-hmm. Okay. Sometimes like our patterns. Yeah. The possibility. wouldn't have said that, I didn't put it,
All right. The time is now 2:46. Our time has passed, and staff informs me that nobody else has requested to testify today. So, as nobody else has registered to testify, that concludes the business of today's public hearing. Again, the record of the public hearing will remain open for 5 calendar days after today. So that's through November 25th, 2025. We'll receive any additional written comments that individuals are interested in submitting up through that date. If you are interested in submitting comments, please do that by sending that to the commission's email address at sentencing.guidelines@state.mn.us. Thank you to everyone who came today. Thank you for sharing your words and experiences with us today. And with that, the public hearing is adjourned.